This third panel is titled Theory and Conflict. Our panelists include Professor Mike Dorf. Professor Dorf is the Robert S. Stevens Professor of Law at Cornell Law School, where he's taught since 2008. Professor Dorf teaches and writes about constitutional law and theory, as well as federal courts. We also have Professor Robert Leider. Professor Leider is an assistant professor of law at Antonin Scalia Law School at George Mason University, where he teaches criminal law and torts and writes about criminal and constitutional law. Rounding out our panelists is Dave Kopel. Mr. Kopel is the research director of the Independence Institute, an associate policy analyst with the Cato Institute, and an adjunct professor at the University of Denver's Stern College of Law. Mr. Kopel writes on constitutional law, Second Amendment, and firearms policy. And moderating our panel is Professor Joseph Blocher. Again, Professor Blocher is a professor of law at Duke Law School, where he writes and teaches about the Second Amendment, weapons regulations, and the freedom of speech. Professor Blocher is also the co-director of the Duke Center for Firearms Law, our partner in today's symposium. Thank you all for joining us. Professor Blocher, I'll turn it over to you.
Thanks very much, Adam. And thanks again to you and everybody else at the Northwestern University Law Review for putting together this fantastic event. I'm honored to moderate this third panel today. I should start by apologizing, as I often do, for not being Sandy Levinson. Some of you who saw an early edition of the schedule may have seen Professor Levinson was scheduled to moderate this panel. Had to move some things around. He'll now be on the fourth panel, which is going to be fantastic. I look forward to that. But in the meantime, we have a fascinating discussion ahead of us with three wonderful panelists engaging various questions regarding the broad theme, as Adam said, of theory and conflict, including ways in which various constitutional values, rights, and interests, including speech, assembly, and the right to keep and bear arms, may be in tension with one another, and also ways in which we might look to the state to protect us from violence, but also to preserve, and necessarily preserve, some space for the use of private force, for example, in self-defense, and also, as our third paper will argue, may have to look to other means to protect against potentially tyrannical states and potentially the use of private violence to prevent that kind of tyranny. But that said, I'm going to get out of the way, turn things over to our three panelists in the following order. We're going to start with Mike, and then Robert, and then Dave. And let me just say, before I turn it over to Mike, again, all participants, please put your questions into the Q&A. You don't have to wait until we get to the Q&A period for that. We'll do a little bit of crosstalk on the panel, and then we'll get quickly to your questions. So please don't hesitate to add them in. With that, I'll turn it over to Mike Dorf.
Thank you, Joseph, and thank you so much to Duke and to the Northwestern University Law Review and to my fellow panelists for being part of this. It's really a great honor to be part of this panel. Let me begin by saying that I do not consider myself to be a Second Amendment specialist. I'm a constitutional law generalist. I have written about the Second Amendment from time to time, and most of my interest in it is in how it relates to other constitutional provisions with which I have somewhat greater familiarity and perhaps greater interest. And so that's going to be the sort of backdrop to my talk today, in which I want to ask what might seem like a fairly provocative question, which is, how does the First Amendment interact with the Second Amendment? In particular, I'm interested in the question of whether together or individually, the First and Second Amendments protect a right to armed assembly. Here's the basic idea, right? The First Amendment protects a right of the people peaceably to assemble to petition the government for redress of grievances. The short form of that is a right to assembly. The Second Amendment might protect a right to public carriage. We don't know yet. The court that decided Heller and McDonald addressed cases involving the possession of firearms in the home. There are arguments available for limiting the right to the home, but there are also powerful arguments for saying that the Heller and McDonald logic protect a right to public carriage as well, at least outside of sensitive places. Indeed, you might think that when the Heller court says that the government can limit the availability of firearms in sensitive places. By implication, there are non-sensitive places besides the home where the government cannot limit it, right? And so if, and I shall assume for the purposes of this argument that there is some right to public carriage, if there is some right to public carriage, then do the two rights combine? That is to say, is the constitutional arithmetic such that the First Amendment plus the Second Amendment add up to a right to armed assembly? And my sort of tentative answer to that question is no. I'll explain how I get there. And then I want to turn to what I think of as the broader question of constitutional arithmetic. How, if at all, do different constitutional rights or other constitutional provisions combine to form new constitutional protections, or do they not so combine? And just by way of preview, the answer is that there are cases in which one can create a constitutional right out of two constitutional almost rights, or more than two constitutional almost rights, but there are also cases going the other way. And so that there is no general rule of constitutional arithmetic that we can derive from the case law. And I'm going to suggest what I think of as a sensible way to think about that kind of question. So again, right, I'm assuming, although I don't have a strong opinion about the question, but I'm assuming that the court would find that there is a constitutional right to carry firearms in public, whether it's concealed carry, open carry, exactly how it could be restricted. That's not exactly my concern. And the reason I'm assuming it is because if there is no right to public carriage, then it seems a fortiori there's no right to public carriage during a rally or a march, because the First Amendment would not by itself provide any special protection for being armed, right? So again, the question is only interesting if there is some right to carry arms in public. Okay, so the conventional approach that constitutional scholars take to analyzing a question of this sort is to go through the usual sources of constitutional meaning, and those are the text, the pre- and post-enactment history, the doctrine, and then sort of normative considerations. There are various ways to slice and dice those concerns, but those are the basics. The text, I think, creates a kind of prima facie right. That's what I've said up until this point, right? That there's a right under the First Amendment to the people peaceably to assemble, and there's a Second Amendment right, I'm assuming, to carry arms in public. So you put those together, and that seems like at least a prima facie claim. So that's, you might count the text as at least prima facie in favor of a right to armed assembly. But of course, that's not where we end, right? We also want to look at the history. And the history, I think, points pretty squarely in the opposite direction, right? So there was an earlier discussion, I think it was with respect to the paper of Joseph and Riva of the Statute of Northampton, right? It features in one of the other papers for this panel. And the Statute of Northampton is a very old statute in England from the 14th century that basically says you can't go about armed. You can't go to the market armed. You can't go in public parks, to the extent that there were public parks, places of that sort, armed. And it mostly focuses on people going armed as a group. And these give rise to a series of statutes that forbid going so-called armed to the terror of the people. Now, if you look closely at the Statute of Northampton, it does appear to bar individuals from going about armed, unless they are in the service of the king or answering a call to arms by the king. And therefore, you might say, well, how much purchase does it have? But for the most part, if you look at the authoritative commentators on this statute and the statutes that come out of it and those in the colonies, right, they seem to distinguish between an individual who's going about armed for their self-defense and a group. And depending on whom you read it, a group can be either 2, 3, or more than 3. but it certainly would encompass the kind of group that you saw attempting to intimidate the Michigan legislature back in the spring, right? Any sort of substantial group who would want to say, hey, we want to have an armed march, right? We want to march through the streets of Washington or Chicago or wherever it is because we want to protest some government policy and we want to carry our weapons, right? They're going to be above the threshold that the Statute of Northampton and its colonial and early American descendants seem to forbid. And you get some of these statutes passed not just in the colonies, but in the early 19th century. Now, that to me is pretty good evidence that the framers of neither the First nor the Second Amendment subjectively intended to create a right of armed assembly. There are other examples from the early Republic that point in the same direction. There's the putting down of the Whiskey Rebellion. There's an interesting episode I recite in my paper involving so-called liberty poles, which are these poles that are put up to symbolize liberty, but you see in the cases involving them that it's the mere assembly is treated as kind of a riot, especially so if the people who are doing the putting up of the liberty pole or getting together are armed. So the general view seems to be that in the colonial period, certainly in England, in the early Republic, a lot of people getting together with their weapons is considered dangerous. Not necessarily a riot, there are different gradations of these things, but dangerous unless they have the sanction in some way of, in England, it would be the king, in the early Republic, it would be the state. Right, and this coexists with notions of the militia, right? So people don't have to be part of. There's a whole discussion in the case law and in the academic literature about the difference between a special militia, the organized militia, the unorganized militia. The point here is that we can assume people have a right to keep their weapons for their personal use under all sorts of circumstances that don't involve militia service. But they can't get together with others because to do so, unless under the auspices of the state, could threaten a kind of revolution. Or put it differently, right? The protection for the militia, right, in the Second Amendment is primarily designed to protect the states against an overweening federal government. Now, I know what you're going to say. Well, what about the fact that people have a right to keep and bear arms under state constitutions, et cetera? That can't be simply under the auspices of the state. And I think that's right, but I think that goes mostly to arms for self-defense. So my reading of the early history, it's not a slam dunk, but it makes pretty clear that there probably is not a right of private groups to assemble armed. You might say, well, but doesn't that get transformed during the course of the 19th century, right? There's an argument that Akhil Amar once made that while the original Second Amendment didn't protect an individual right to firearms possession, the 14th Amendment, when it incorporated the Second Amendment, did. This isn't an approach that anybody currently takes, right? There's no version of incorporation in which the rights incorporated are more robust against the states than they are against the federal government. Indeed, last term's decision in Ramos against Louisiana says basically if a right is incorporated, it means exactly the same thing against the feds as it does against the states, but it is a conceptual possibility to say that you could have a more robust Second Amendment right against the states as incorporated than you do as against the federal government. But looking at doctrine, that doesn't seem very plausible, given that if you read Justice Alito's opinion in the McDonald case, which incorporates the Second Amendment against the states, among the episodes that he's most concerned about are the fact that the freedmen, African Americans, right, are being attacked by armed groups, the KKK, their predecessors, their successors, right? It's armed groups that are acting outside the auspices of the state that are part of the worry that gives rise to the need for individuals to be able to arm themselves. There might be some protection for armed groups arming themselves sort of in their own homes, right? So you could imagine that there's no right to armed assembly, but there could be a right of people who are sort of, cowering in fear to have arms as a group. The fact that there are, more than 3 of them wouldn't undercut their right to self-protection. But as a general matter, when I think about armed assembly, I think about a kind of public march. And the worry, of course, is that if you say, well, every private group gets to say that they are the lawful ones, that's going to lead to clashes between armed groups. And so the history through incorporation, and as I see it, the doctrine under the Second Amendment point at least modestly against a right to armed assembly under the Second Amendment. With respect to the First Amendment, I think the case is much more clear-cut, right? The government is allowed to enforce content-neutral time, place, and manner restrictions on speech, including on rallies, marches, and so forth. And here, so of course, the government couldn't say that it's going to forbid anti-vaxxers from being armed when they have a march, but not pro-vaxxers, Republicans, Democrats, and it couldn't do anything based on the content. But if you had a content neutral rule that said, if you want to apply for a permit to march down Michigan Avenue in Chicago, the permit's not going to permit the people to carry arms, as long as that was applied in an even-handed manner, I think that wouldn't raise any questions under the First Amendment. The First Amendment does require that even content neutral restrictions be reasonable, but here it would be reasonable because it would be aimed at protecting the public safety. And I go into that in a little greater detail in the paper. I'm talking fast, but I'm still running out of time. So I'm going to try to pivot now to what I think of as my special contribution to this paper. I mean, the history I can look at just like anybody else, but my contribution here is to sort of compare and contrast this with constitutional arithmetic in other domains. And there I want to say that there are contexts in which the court has, I think, sensibly combined different constitutional doctrines or rights. So a nice example is the combination of federalism and equal protection that one sees both in the Plyler case, finding that the prohibition of public education to children who are undocumented immigrants is unconstitutional, and in the Windsor case, finding that Section 3 of the Defense of Marriage Act was unconstitutional, even prior to finding a constitutional right to same-sex marriage. That in both those cases, there's a nice, or I think sensible way in which coming close to a right or coming close to federalism protection triggers a kind of heightened sensitivity with respect to the other concern. Having said that, I think there are also contexts in which the court somewhat nonsensically combines rights, and I'll just give two examples. So one is Justice Douglas's opinion in Griswold against Connecticut, which has been almost since the day it was written pilloried for its use of penumbras and emanations to claim that the right to contraception comes out of the rights of the First Amendment, the Third Amendment, the Fourth Amendment, all of which sort of combined somehow. I'm not saying the case is wrongly decided. I think it's rightly decided, but it's rightly decided, as Justice Harlan says in his concurrence, because it's an exercise in substantive due process. Similar example, in Employment Division against Smith, Justice Scalia attempts to distinguish prior cases that had found rights to religious exceptions from general laws, in particular in the Yoder case, by saying, well, those weren't free exercise cases. Those were cases of free exercise combined with the right to raise children. And yeah, it's true there was that combination there, but there's no explanation of why the two rights combine. And so, though there are these examples of saying you can get two rights having the sum greater than each individual, but they're not always all that well thought out. And then, of course, there are cases that go the other way. So there's a case called Zurcher against Stanford Daily, in which the court rejects the idea that the First Amendment would provide heightened protection under the Fourth Amendment to a newspaper as the target of a search. I think that case is wrongly decided because I think that actually there ought to be some protection, but you can see that just as the court overprotects combinations in a case like Smith, it sometimes underprotects in a case like Zurcher. I think more generally, the presumption should be that combinations don't give rise to protection where individual rights don't. Let me just give you a kind of silly example, right? So there is a right to, under substantive due process, of people to have, of adults to have consensual sex in private. There's a right for people to walk around in public, absent some compelling government interest in preventing that. But you don't combine them to say that therefore there's a right to have sex in public, right? And it seems to me almost everything works that way. In general, you either have a constitutional right or some constitutional benefit under a structural provision. The fact that you almost have one under one and almost have one under another doesn't generally mean that they combine. And so I reached the same conclusion with respect to the First and Second Amendments, which is, in principle, we could imagine that the two could combine to create a right to armed assembly. But in practice, I don't see a reason why there would be that kind of synergy between them. Okay, I've talked too long. Let me stop there and turn it over.
Thanks so much, Mike. That was fantastic. I'm going to, in turn things over to Robert Leider, our next presenter.
All right, thank you. So I'm going to talk a little bit now about why we might devolve some force, not just defensive force, but some of the government's monopoly of force to private citizens. So the common assumption today is that governments possess a general monopoly on the legitimate use of force. And the only recognized exception to this monopoly is that individuals have a right of self-defense against immediate threats. In the Second Amendment space, the strong monopoly of force approach has several implications. So first, there's this general hesitancy to recognize any right of individuals to use violence except in personal self-defense. Individuals who, for example, undertake private law enforcement duties are labeled vigilantes. To foreshadow David Kopel's paper, the idea that a population may need to rebel against an oppressive government is dismissed as insurrectionist. The idea is that the means of political violence must remain exclusively in the government's hands. And not just in the government's hands, but in the hands of the government agents. So the only people who can exercise the government's monopoly of force are professional government employees. And correlatively, many scholars today see the individual right to keep and bear arms as protecting only those arms that are necessary for self-defense against criminal wrongdoing. So we see this in Heller and McDonald, right? They place handguns as the paradigm weapons that individuals have a right to possess. Scholars and judges widely accept the constitutionality of bans on certain semi-automatic weapons and high-capacity magazines. And these weapons and accessories have their primary value for public defense and law enforcement. They have some self-defense value, but they're rarely necessary for, say, individual self-defense against burglars. Yet this conception of the Second Amendment as protecting only individual self-defense is at odds with the Constitution itself. I mean, if you look across the structure of the Constitution takes pains to decentralize the means of political violence. The framers during the Constitutional Convention spent several days debating whether the federal government could even maintain a peacetime standing army, and whether states or the federal government would control the militia. Before guaranteeing the right of the people to keep and bear arms, the Second Amendment begins a well-regulated militia being necessary to the security of a free state. And even before the Constitution and the Second Amendment were adopted, there was a long Anglo-American tradition of decentralizing the use of force. Since the Middle Ages, private citizens have had robust authority to make arrests for public crimes, to use force to keep the public peace, and to keep and bear arms. Now, the story that we often get is that the decentralization of political violence is anachronistic. So that when the Constitution was adopted, the country did not have a powerful standing army or professional police. And of course, we have these today. And so we are told that the Second Amendment no longer has relevance for public defense or private law enforcement. Political violence must remain in the exclusive hands of the government through its professional agents. And that today, the right to bear arms only has value for individual self-defense against crime. Now, my paper pushes back on this narrative. And for three reasons, I argue that the decentralization of political violence remains a crucial part of our system today. First of all, we have rampant under-enforcement of the law. Second, there's a mismatch between private rights and public duties. There is no private right to police protection and no way to go to court to seek more of it. And third is that the government agents themselves are imperfect conduits of government power. They can commit nonfeasance or misfeasance, and I'll talk a little bit more about that. Now, let me preface this remark by saying that the theory that I outline in the paper is susceptible of one of two different interpretations, and I think my theory is compatible with either one. The first theory is that our system really doesn't recognize a government monopoly of force at all, but just decentralizes the means of political violence, and that the government is a source of legitimate political violence. It may even be the primary or most important source, but it is not the only source. And I think there's a second view, which is as no, the government really does have a monopoly on the legitimate use of force for political purposes, but the government can distribute that force however it wants. It can delegate that force to state actors, or it can delegate that force to non-state actors, as Anglo-American law has traditionally done. Now, in some earlier papers, I've adopted more of the second approach, but I think what follows is compatible either way. All right, so first of all, the first reason that the private right to use force for reasons other than self-defense remains relevant is we still have pervasive under-enforcement of law. And wow, under-enforcement. I mean, over-criminalization is what garners all the attention in the law reviews. But when you look at, when you measure by clearance rates, which are, arrests versus reported crimes, police make arrests only for 62% of all murders, 35% of all rapes, 30% of all robberies, 14% of all burglaries, and 19% of all thefts. And, overall, the official police clearance rates are around 45% for violent crime and 15 to 20% for property crimes. And even these numbers may overstate police effectiveness. Many individuals don't report crimes. They consider them to be a personal matter, or for whatever reason, crimes don't get reported. And in 2018, police cleared about 10% of all known crimes when you measure it with other sources like the National Crime Victimization Survey. It's something like 62% of murders, I think 6% of rapes, 14% of robberies. So the amount of law enforcement that we supply is actually much less than what we need. And that's especially true in poor and disadvantaged areas. So policing, one thing about policing, as people like David Skolansky have noted, is that policing is redistributive. It is paid for by tax dollars, which primarily come from middle and upper class people, but the primary people who need police services are often located in poor areas, which have disproportionate amounts of crime and especially of violent crime. And that's just the ordinary picture. During the riots, the under-enforcement can be even worse. I mean, we've seen in a lot of communities that the police have, quote, backed down and allowed the establishment of autonomous zones. The Minneapolis police backed down while rioters burned and looted one of the police stations. During the LA riots, I think it took about 3 days for store owners to get access to police services. So during times of emergency, access to police services may not be available. Now, the second reason that Anglo-American law, I think, has traditionally decentralized the use of force and that remains relevant today is that there's a mismatch between public duties and private rights. Courts have virtually uniformly held that the provision of police services is a public duty. And by this, they mean that it's a duty owed to the community generally, but that no individual person has a private right to enforce that duty. And so if somebody lives in a community where police protection is not provided in adequate quantity, he can't go to court and get an injunction and say to the government officials, you need to provide more. Nor, if he's injured by criminal wrongdoing, can he go to court and seek compensation from the state. The reality is that the duty is of a nature of an imperfect duty, and individuals have no way to enforce it. Individuals not only have no way to enforce it, they have no way to get redress when the obligation to provide police services is violated. And so what ends up happening is that people who are victims of crime can't really seek redress in the justice system. Many people who perpetrate crimes are never found. Those who are found are often judgment proof, and individuals can't go to court and seek redress from the locality which may have underprovided law enforcement services. The third reason that I get to in the paper is that even if the government as some abstract incorporeal entity has a monopoly on the legitimate use of force, it does not follow from that the only way that force may be exercised is through professional government agents. And again, as I indicated earlier, there is also this kind of weak monopoly of force view that the government is authorized to exercise its monopoly through non-state actors, which is what Anglo-American law has traditionally done. And if you look at English law has taken two angles with respect to private law enforcement. First of all, when a public officer exceeds what he is authorized to do, the traditional rule before modern qualified immunity is that peace officers were trespassers. They were effectively acting as private citizens, and they were in no better position than any other private citizen. And the second is that private individuals had robust authority to make arrests. Even through Blackstone, the private and public powers to arrest are almost coextensive. Police, at least in the United States, did not get probable cause arrest authority until the 19th century. And in England, it was towards the end of the 18th century. And I think underlying that are two general principles. First, even if the state has monopoly of violence, again, there's nothing inconsistent with allowing private citizens to exercise that monopoly. The government's distinctive claim here on those of those subject to its jurisdiction is the duty to have the government's directives obeyed. A private citizen enforcing the law consistent with the state's directives is not acting in derogation of the state's monopoly of force. And that's my second point, that individuals can also exercise government force consistent with whatever we would view as the state monopoly. All right, so I've just given about 8 minutes or so of reasons why we should decentralize political violence. And all of these reasons sound like, well, I'm really making a monopoly of force argument, right? What I'm saying is we underprovide police services, and therefore what we need to do is provide more of them. That this isn't really different in kind from what others have argued in terms of governments maintaining a monopoly of force and the individuals having a right to act in immediate self-defense. What I'm saying is this is an argument for the government to provide more police and more security services. And I want to step back here and say, no, that's not necessarily the lesson of what I'm trying to say. Because even while we grossly under-enforce crimes, we also paradoxically suffer from pervasive over-criminalization. Police harshly enforce regulatory crimes, especially drug offenses, against some communities rather than others. Bill Stuntz's book, The Collapse of American Criminal Justice, noted that whites, Latinos, and African Americans use drugs at approximately the same rates, about 8 to 10%, but that African Americans were 3 times more likely to be in prison for drug crimes. So it's not just a question of how much police services we provide, but how we distribute them. And there's a good reason to believe that if we simply increase the amount of police services, we might actually make the overcriminalization problem worse. Police are incentivized to ferret out crimes. Police are often promoted by how many crimes they detect and solve. And so just flooding an area with more police could lead officers to make arrests for easy regulatory offenses rather than trying to prevent, say, violent or property crime, or making arrests for property or violent crime. The effect of police in suppressing crime is very hard to measure. Police can, on the other hand, detail exactly how many arrests that they made for drug crimes. Second, on the private right versus public duty aspect, some have argued, well, maybe we should just abrogate this and create a private right to police protection. And I think this is a terrible idea. A private right to police protection would create enormous separation of powers problems. It would essentially put judges and juries as the overseers of our national police forces. There simply isn't enough policing services to detect every crime. And judges and jurors, judges and jurors do not have special expertise as to how policing services should be allocated. And so the idea that you can go to court and say, well, the police chief got it wrong is, I think, a very terrible kind of judicial supremacy. It would also be the case, it's also the case that that the political boundaries in our communities are drawn in ways that are sometimes regressive. So an individual who would have a private right to police protection may very well be seeking indemnity from a municipality that is ill-equipped to pay. And so a business owner who has his business looted may be seeking redress from a community that already can't provide basic governmental services. And so I think between having individuals have some access to private self-help, or allowing communities of individuals to organize for their own defense, and turning over the decisions about how to allocate law enforcement to juries and judges, and requiring political communities to indemnify homeowners and business owners who are injured, I think allowing, decentralizing political violence is the preferred course. And my third point is that not only are public officials commit nonfeasance by enforcing the laws, they also commit misfeasance. And so decentralizing political force decentralizing force allows individuals to resist illegitimate use of power. So take the George Floyd case and the officer who was kneeling on his neck. I think if a private citizen had pushed the officer off of George Floyd's neck, the private person would have a much better claim to exercise the state's monopoly of force than the officer with the badge who was using illegal violence. And so I think my overall point of this paper is that the decentralization of political violence serves small r Republican ideals, the idea of freedom is non-domination. And of course, the way modern gun politics are, perhaps my paper also serves big R Republican thoughts too. But the main point is one of small r Republicanism. The idea of freedom is non-domination. And freedom is non-domination means non-domination both against private and against public acts. And the main argument of the paper is that the decentralization of political violence is a better way to prevent non-domination than it is to just continue to centralize more violence in the state. Police are paradoxically both the people who prevent crimes and occasionally the source of oppressive behavior. And when you centralize all the violence in the state, there can be a thin line between not providing enough police services and having some anarchy, and providing too many police services and having a police state. And decentralizing political violence helps avoid either extreme. My final note is, somebody's going to obviously object here and say, isn't this just a call for vigilantism? And I think not, and for two reasons. One is, I think there's a crucial distinction between defensive and offensive force, that individuals who exercise purely defensive force don't interfere with the state's power to enforce the law or to do political acts. And a lot of what individuals do is defending their homes and businesses and themselves against unlawful violence. But the second is that to the extent that individuals have offensive force and have the power to make arrests, there's also a key distinction between using that force consistent with government policy and using that force against government policy. So I think there's a big distinction between individuals who say patrol their neighborhoods during a riot to prevent looting, not just of their premises, but of the wider community, and individuals who decide that they're going to take up arms at the border and enact their own immigration policy, where US law has both formally banned people coming across the border in an unauthorized fashion, and yet the federal government has taken a conscious decision not to enforce that law to the maximum amount possible. The concerns of vigilantism really get purchased where individuals are using political violence against the government's decisions. But that individuals who use it consistent with government policy aren't usurping the authority of the state. And I think, again, we distinguish defensive and offensive crimes. I think individuals who are engaged in private law enforcement for what are the core common law crimes, murder, rape, robbery, and so on, aren't doing anything against government policy. These are the kinds of crimes we expect the government to prosecute in all cases where the defendant may be found. And on the other extreme, individuals who start enforcing mala prohibita regulatory offenses really can create tension with government policy. So the question isn't, in my mind, should we have public or private enforcement? I think the combination of both is ideal. But much like decentralization of force, the crucial question is how does the decentralization occur? But I do think, and I will end on this note, the decentralization of political violence is both a historical part of our system and a valuable part of our system today.
And that is an excellent segue, I think, to our last presenter. I'll turn it over to you, Dave, and then we'll go to the Q&A. Just as a reminder, the question box is starting to fill up. Please submit your questions. We'll get to those as soon as the last presentation is over. And with that, I'll turn it over to Dave.
Good afternoon, and like Professor Blocher, I too would like to apologize for not being Sandy Levinson, but the fact is there's only one of him, and so the supply is limited, and there's nothing we can do about that. So one common argument against American gun rights is that Europe has much more gun control than the United States and is therefore much safer. My article looked at the comparative dangers of excessive gun ownership and of excessive gun control based on the historical record of the 21st century. Excuse me. So let's take a look at the first side of that. The largest global data set, my apologies. The largest global data set for firearms homicide was published by the Journal of the American Medical Association in 2018. And the first year for which they had complete data was 1990. And that was a very high year for firearms homicide in the United States. The US age-adjusted homicide rate, firearms homicide rate, that year was 557 homicides per 10 million population. In contrast, the European average was 92 firearms homicides per 10 million population. So there were about 465 more firearms homicides per 10 million people in the United States than in Europe. Now, take that rate, which is that spread, and it's a big spread because, again, 1990 was a bad year in the US. Apply that through all the years for the US population from 1901 through 2000. And at that rate, the United States, over the course of the century, had about 745,000 more firearms homicides compared to the European rate. Now, let's assume that none of the additional American gun homicides would have happened if the United States had European-style gun control. So we're going to presume that zero of the killers would have substituted a different weapon. And we're not going to consider the fact that some gun homicides are justifiable self-defense. And we're also not going to consider how often non-fatal defensive gun uses prevent homicides or other crimes. So with these assumptions, the absence of European-style gun control in the United States was responsible for almost 750,000 excess deaths in the United States in the 20th century. That is a very large number. Yet it is over 2 orders of magnitude smaller than the number of Europeans killed by their governments in the 20th century. Murder statistics usually only count murders by individuals or small groups. But murder statistics that don't count murder by government are missing a very big share of the murders. The late University of Hawaii political science professor, Rudolph J. Rummel, comprehensively collected data on mass murder by government globally from 1900 to 1987. During those years, governments around the world mass murdered over 200 million people. And that figure does not count battle deaths from warfare, which were about 35 million by his estimate. The most murderous regime was Communist China, which killed over 80 million. In Europe in this period, 87 million people were murdered by government. Professor Rummel's estimates were as follows. Soviet Union, 62 million, including over 5 million killings in other Eastern European nations. The Russian Tsars, 600,000. The Nazis, 21 million, all over Europe. Poland's post-World War II ethnic cleansing of Germans, 1.6 million. Communist Albania, 100,000. The Balkan Christians who were killed by various governments in 1912 to 1913, 10,000. Communist Bulgaria, 222,000. Czechoslovakia's ethnic cleansing of Germans, 197,000. Communist Bulgaria, 70,000. Hungary, which had both fascist and communist regimes, 138,000. Romania, which was also fascist and then communist, 919,000. And Spain, 450,000, of which 250,000 were killed by Francisco Franco's communist regime, fascist regime, and another 200,000 civilians killed by both sides during the Spanish Civil War. So I'm alive to speak today because my Jewish, German, and Lithuanian ancestors migrated to the United States in the 19th century. By moving to the United States, they increased their risk of being shot by an individual criminal, and they drastically reduced their risk of being murdered by criminal governments. Those risks did materialize in Germany under the Nazis and the communists, and in Lithuania under the Tsars, the Nazis and the communists. Governments are much more effective at killing than are individual criminals, even the aggregate of all individual criminals. So when you look at the full picture of homicide, the United States was much safer than Europe during the 20th century. Now, the best means to reduce the risk of mass murder is not to have a totalitarian government, especially not a communist one. So here are a pair of charts from Professor Rummel. Let's see if I can bring those up. All right, so what we see here is on the 3D chart and then on the straight line, both basically telling you the same thing. The less free the government, the more likely it is to perpetrate mass murder. Totalitarian regimes perpetrate by far the most, authoritarian regimes less so, and democratic ones least of all. The more government power, the more mass killing. And by the way, Professor Rummel has found this to be true even when you consider other variables such as culture, diversity, all of those other kinds of things. The culture and other influences that do affect society in many ways don't seem to be successful at making it a government more or less likely to perpetrate mass murder. So if you could be certain that a particular government would always be free, there would be no need for citizen arms to deter or resist mass killing by government. Unfortunately, there can be no certainty of permanent self-government and democracy. How many nations since 1900 have, 1, maintained independence for the whole time, and 2, maintained free government during the whole time? There are no such nations in Africa, Asia, South America, or Central America. The full list is Australia, Canada, Iceland, Sweden, Switzerland, New Zealand, the United Kingdom, and the United States. That is 8 nations out of nearly 200 in the world. So only a foolish version of American exceptionalism would imagine that the United States has been granted some kind of permanent immunity from the dangers of totalitarianism. People often tell themselves that it can't happen here. Yet it did happen almost everywhere in Europe, including in democratic, economically advanced, and socially progressive nations such as Germany and France. Adolf Hitler explained why disarmament was so important to him. He said the most foolish mistake we could possibly make would be to allow the subjugated races to possess arms. The supply of arms to the underdogs is a sine qua non for the overthrow of any sovereignty. And in that respect, he was quite mainstream among historical tyrants who have been very diverse in terms of their ideology, their culture, races, all kinds of circumstances. Yet they have many common practices across time and across different geographical locations. And one of those is attempting to acquire a monopoly of arms. And then after they feel they have that, then comes the mass killing. Some recent examples: Darfur, Sudan in the 21st century, Indonesia's ethnic cleansing of East Timor in the 1970s, Srebrenica, Bosnia in the 1990s, Kenya and Uganda from the 1960s onward, and Ethiopia against the Anuak tribe in the 21st century. What Plato and Aristotle observed in their time is and always has been the same. A tyrant aims to make the state stronger than the people. Now, of course, although tyrants always disarm victims, disarmament does not always lead to tyranny, at least not immediately. For example, today the people of Luxembourg and the Netherlands have been almost completely disarmed, but those nations aren't tyrannies. In the short to medium run, a disarmed nation can remain free. Whether that is so in the long run is more questionable based on the 20th century's political history. If you remove the seatbelts and airbags from your car, you may never need them. If you imagine that your nation is permanently immune to dictatorship or conquest, then you might give up your last resort safety tools. History suggests that would be a gamble. As an anti-tyranny tool, widespread citizen arms ownership is most effective when it deters. In England in the 1500s, the very existence of a well-armed population during the reign of King Henry VIII deterred the despotically inclined monarch from pushing things too far. During World War II, the most important reason there was no Holocaust in Switzerland was that the Swiss people were very heavily armed in a very well-regulated militia. The deterrent effect of armed victims more broadly is demonstrated by the timelines of tyrants. They attempt to disarm the victims before the mass murder commences. Sadly, sometimes the possibility of deterrence is long past. Yet even after mass murders have already begun, when victims obtain arms, they can save lives. Even when there is no hope of overthrowing a tyrant, resistance can accomplish quite a lot. The Sudanese government's genocide campaign in the Nuba Mountains failed because the Nuba people were better fighters than the government's militias. The Nuba were cut off from the world, they had no resupply, no vehicles, no heavy weapons, and sometimes they were down to only a handful of bullets each. In a war that lasted from 1983 to 2005, the Nuba did lose some territory, but they stayed alive in their bases in the mountains. During World War I, the Ottoman Empire perpetrated genocide against Armenians, Assyrians, and other Christians in Turkey. Armed resistance made it possible for over 200,000 potential victims to escape to Russia and Persia. In fortified towns, monasteries, and other defensible positions, besieged armed Christians often were starved out and killed, but sometimes the attackers retreated and a village survived. During World War II in Eastern Europe, a single Jewish partisan unit, the Bielski brothers, saved over 1,000 Jews. Armed revolts in the cities, most famously the Warsaw Ghetto Uprising, didn't save the lives of the fighters, but they did prove to the world that Jews weren't just victims. They were allies fighting in the common cause, and they deserved a share in the post-war settlement. There is a direct line between the Warsaw Revolt and the 1948 establishment of the State of Israel. Israel's armed Jews successfully defended themselves against a war of extermination in 1948, and they have done so repeatedly since then against subsequent wars attempting to exterminate the Jews. Tibet, after many years of self-government, was invaded and conquered by communist China in 1951. When the communists mandated gun registration, everybody knew that confiscation was next, and so a national revolt began. By mid-1958, most of Tibet's land had been liberated. Ultimately, China's overwhelming numerical superiority finally defeated the Tibetans. But in the meantime, 80,000 Tibetans escaped. Among them was the Dalai Lama. As refugees in India, Tibetans kept their religion and culture alive, and they continue to bring global attention to the rights of all the Tibetan people. There is no certainty that armed resistance will defeat tyranny. There is certainty that every mass-murdering tyrant tries assiduously to disarm those whom he intends to subjugate and murder. Thank you.
And thank you, Dave. We are going to now go straight to the Q&A, and I am going to exercise the opposite of the traditional moderator's privilege, which usually the moderator puts his or her questions first, and instead go to the very robust Q&A that has started to form here. I'm going to do my best to work through as many of the questions we've already received as I can, synthesize them and sort of distribute them across the panel. But please, we're happy to have more questions, and I'll do my best to try to pull some of them together. Let me start with a question we received for Mike, and I'll maybe add a little spin on this one and summarize it a bit. Professor Dorf, why do we need to add rights together at all once you assume, a sort of prima facie at least, a right to public carry? Shouldn't that get us all the way to armed assembly if we assume there's a difference between a threatening armed gathering and a peaceful one? In other words, if there is some right to public carry, how does it get subtracted when it's exercised sort of collectively? And maybe sort of an additional argument on there would be, or additional question, I guess, would be, to maybe say more about whether your argument is sort of categorical, that there's a threshold, bright line, no such thing as constitutional protection for armed assembly, or rather that it gets through the gate and gets constitutional coverage and yet is regulable under time, place, and manner restrictions or something along those lines. So I'll turn that one to Mike, and then we'll come back with some more questions. And obviously, Robert or Dave, if you have thoughts on that one too, feel free to weigh in. But to you first, Mike.
Yeah, that's a great question. I address it in the paper in a number of ways. So I hypothesize an assembly of Korean War veterans who would necessarily be quite old, who want to march and want to carry with them either their rifles from their service or their service revolvers or whatever it is, sidearms. And I say, yeah, we could imagine a march or rally in which people are armed, in which it would pose no threat to the public safety because no one would understand them as threatening. And if it's a Veterans Day march, no one is thinking, oh, that's an offensive message. You're not going to imagine counter protesters. So yes, it is possible to imagine people having an assembly, an expressive assembly while armed that does not pose a danger of a breach of the peace or a threat to the kind of communal life that Joseph and Riva talk about in their paper. The difficulty is that in order for such an assembly to be legal, typically you would need to apply to some sort of government official for a march permit or an assembly permit, right, if it's a substantial gathering. And now imagine the position you're putting that person in evaluating whether to allow this group or that group to be armed or not. Seems to me it's going to be very difficult to make that judgment without reference to the content of the speech, right? Either because of its offensiveness and thus the likelihood that it's going to spark counter-protests, which could cause a breach of the peace, and then if there's arms, that could become explosive, or because the protesters themselves pose a risk of a breach of the peace. We know from a case called Forsyth County against the nationalist movement that even the risk of a government licensor taking into account the unpopularity of the speech in figuring out how much to charge for police protection against counter-protesters is impermissible content discrimination. And so as a kind of prophylactic measure to avoid putting the government in the position of making content-based or viewpoint-based distinctions for who gets to have their marches armed and who doesn't, my feeling is that it's you could have a blanket rule saying you simply cannot carry weapons if you are holding one of these marches, and that would be a reasonable time, place, and manner restriction because you are not appreciably, first of all, you're not targeting the content, and second, you're not appreciably limiting what people can say. With respect to your question, Joseph, whether it's categorical. So it depends on how you get there. If you get there by the way that then Judge Kavanaugh wanted to, as an appeals court judge, right, not looking to levels of scrutiny, but using sort of going directly to text and history, then I think it's categorical because then you would say, well, the text and history of the respective amendments do not establish a right to armed assembly, full stop. I don't actually think that's the right way to think about the Second Amendment. I think it's not it shouldn't be thought of categorically differently from other amendments. And so I do think there are levels of scrutiny. And so I could imagine that there would be special circumstances in which a general prohibition on armed assembly would be susceptible to an as-applied challenge. For example, in a group that is especially vulnerable, especially if there isn't adequate police protection and so forth. But that, to me, that's the exception. So yes, I would say it's amenable of exceptions, but the general analysis takes me to say that there isn't a prima facie right to armed assembly.
Let me pair together the next two questions. They came in separately, and one's addressed to Robert and one's addressed to Dave, but I think they're picking up some similar themes, so I'll just sort of ask them collectively. So this one was addressed to Robert, but I think anybody could answer it. In your view, is there a limit to how much the government could devolve the monopoly of force to individual citizens? Anything like a non-delegation principle in this context? Anything to stop the government from, say, allowing private citizens to use lethal force anytime they subjectively think it warranted? Given recent events in Michigan, this would seem like a bad thing. Also, how does this square with the founders' fear or rejection of events like Shays' Rebellion, where political violence was fully devolved? So, and then another question, which I think is raising some somewhat similar themes here, especially about perceptions of tyranny. If one accepts the notion that one purpose of the Second Amendment is to ensure the ability of armed citizens to resist tyranny, as Heller states, how does that idea play out in our current circumstances where Americans are deeply divided about what is and is not tyrannical? Some people see Governor Whitmer as a tyrant and allegedly think they're justified in kidnapping and possibly killing her. And those people support Donald Trump, who is reasonably seen by a huge number of Americans as posing a much more serious threat of tyranny, in particular fascism. In this environment, how can the resistance against tyranny approach be implemented without running the risk of civil war? And part of this, I think, is a threat perception question, but also, you know, whose views of tyranny get privileged here?
All right, I guess I can pick it up. So I think so I guess three things in response to the three questions. One is, how much force can the government devolve? I think the government can devolve all the force that it can legitimately exercise itself. So the question isn't a quantity question so much as it is a qualitative question or the nature of the force. So for example, today we have robust professional police departments. I don't think it's inherently necessary or conceptually necessary that a government maintains a police department. I think if it wanted to and thought it was efficient, it could, as you know, during our framing generation, devolve private law enforcement to private individuals by qui tam or other forms of private criminal complaint. But I think that's a different question from the question of the kinds of force that it can devolve. I think there's a big difference between the government devolving its law enforcement authority and the government saying, oh, you can just shoot anybody that you think is a threat on site. The government could not legitimately exercise that power, and therefore I don't think the government could legitimately authorize private citizens to do so too. Second, on the Shays' Rebellion point, Shays' Rebellion is a classic example of political violence, but I think it's not the kind of decentralized political violence that I'm talking about. So as I said towards the end of my presentation, offensive violence, where you purport to enforce the laws or to have some sort of other principle other than immediate self-defense, I think is a dangerous place for private citizens to be. And it's a dangerous place because it can be exercised in one of two ways. It can be exercised consistent with government policies and principles, and it can be exercised in a way that's antagonistic to them. And where Shays' Rebellion went wrong is that you had an armed group who fought the democratically enacted laws of the United States. And the fact that you decentralize political violence does not imply that you have to allow private actors to resist whatever laws they think are improper. If you imagine a different situation where private individuals decided that they would enforce the law against people who were evading taxes, I don't think anyone would have had a problem with that. I think where Shays' Rebellion went wrong is that they were forcibly resisting the laws of the United States. And in terms of who enforced the laws of the United States, I don't think it matters whether you have a tax collector or a private citizen do it. Now, it does matter in some of the details, but I think it's just a kind of broad perspective of political theory. There's no one right way to do it. There are good and bad ways to implement either state agents doing it or non-state agents doing it. In terms of, that kind of brings it, I think, to the last question, which Dave may be better positioned to answer, but in terms of resistance to government authority, this has always been a huge question in terms of the Second Amendment, because At least some theme underlying the framers' writing is that there may be cases where armed revolution is necessary. The framers, of course, themselves had just engaged in it. And this is very uncomfortable when you have a system of government and of laws. And I think the dividing line for the framers would have been resisting illegal usurpations of power versus resisting legitimate democratic government. That is, you couldn't resist the duly enacted laws of the United States simply because you disagreed with them. But that was different in kind from resisting people who exercise more than their constitutional authority. So the classic example for the English would have been the king ruling by proclamation in the 17th century and doing a bunch of acts that were thought illegal and against British constitutional norms. And so, I don't think the Declaration of Independence talks about revolution. It doesn't say you can do it on the mere whim that you don't like the policy or you don't like the office holder. It's really talking about circumstances where people, where you don't have functioning democratic government, where the rulers are not obeying the rule of law. And so I'll end on that note. I think there's a crucial difference between using force to disagree with duly democratically enacted policy and using force to resist those who do not, who have usurped the lawful authority that they've been vested with.
If I could add in quickly to supplement Robert's remarks, for the American founders, this is it was a much more straightforward question than it seems to be to some modern people, because they knew of an intellectual tradition that went back to the best-selling book of the 1100s, Polycraticus by John of Salisbury, and then as those views were brought forward by Catholic and Protestant political and moral theorists, the stage at which you say the guy who purports to be the ruler of our country is illegitimate, he's a usurper, he's a tyrant, or whatever, that is not a decision normally to be made by just an individual on his own feelings. Their view was, their resistance theory relied on what were called intermediate magistrates, the aristocracy, the local governments, the local parliament, whatever. And in the United States context, in 1776, it was very straightforward. It was the state governments that were the crucial point, and that was added to the legitimacy of the Declaration of Independence. It wasn't just several dozen guys who wrote something. Every one of them who signed the Declaration was doing so as a representative of a state government. And you see that again in Madison's Federalist 46, where he talks about what he sees as the unlikely possibility of federal tyranny. But he says if it did happen, you would have the well-armed American people in their militias led by the state governments. And those were the two crucial things he contrasted with Europe, where they not only didn't have an armed population, but they didn't have really effective partly sovereign centers of power outside of the central government. But on the smaller question of just caring for personal defense, such as in a political demonstration, that's one's decision to do whenever. And I think that the Second Amendment makes that clear enough. And good examples of that would be the Deacons for Defense and Justice, one of the civil rights groups in the 1960s, starting in southern Louisiana, who collectively worked together to protect our peaceful demonstrators. And in fact, when Dr. Martin Luther King led the Meredith March Against Fear, a march from Jackson, Mississippi to Memphis to register voters, he was protected by the armed group of the Deacons for Defense and Justice. Now, under Professor Dorf's theory, the government could have outlawed that. But I think, in fact, and his idea is, well, if there's a political demonstration, you're worried the people on the other side are going to kill you, you just ask the police. That doesn't seem to work out so well. Often, historically, we've had cases in Denver where the police stood aside and a mob of communists attacked peaceful demonstrators 2 blocks from our state capitol, and it was an even more serious problem back during the civil rights movement. So peaceable, lawfully armed, defensive people can work together to help provide legitimate protection. And by the way, in the Meredith March Against Fear, you certainly had some armed police who are not exactly friends of civil rights, and you had the armed protectors of the marchers, the Deacons for Defense, and not a single shot was fired. So the mutual equality of force rather than a government monopoly of force was one of the things that helped to promote the peace there.
So let me ask a quick follow-up, and I'm going to do my best to synthesize a lot of themes that are emerging in the Q&A, and I'm going to just those to the panelists, each of you to give a short response. I think a lot of the lines that I hear being drawn are sort of between unlawful violence and sort of self-help and private law enforcement, between offensive and defensive, between tyrannical and non-tyrannical. But I take the thrust of a lot of the questions and a lot of the problems here to be that those are questions in the eye of the beholder, and there's going to be big disputes where people are probably likely to systematically overstate their own interests and the feeling and the degree to which they've been wronged. The sort of, everything we know about people's failures of threat perception, the biases, racial and otherwise, that creep into that, it is likely to sort of distort the responses such that even the offensive defensive line that we're trying to draw there is just not going to hold, because as we see even in the context of the Michigan people who were arrested in Michigan, who describe themselves as defending the Constitution against a tyrannical government, and I don't doubt that they believe it fervently and honestly. So I guess the question here and what it puts in mind is, because we've heard a lot about sort of Locke today, John Locke has a very strong statement in favor of self-defense, but it's also Locke who recognized the danger of making a person a judge in his own case, and that people are likely to overvalue the rights and interests of themselves over others. Can we address the threat perception question? And I apologize, we only have a few minutes, but I do want to hear from all three. So maybe just quickly, each of you in order, and then we'll take a break. Maybe start with Mike, since you went first.
Sure. So that, yeah, and I'll use that also to respond to something that that Robert and Dave respectively said in response to the last question. So I completely agree that much of this is in the eye of the beholder, and that's why the state monopoly on force, even if it's not, there are other ways of doing things. It makes quite a bit of sense to me, subject, of course, to our devolving it through democratic means. So I want to caution that one might disagree with me. You could agree with Dave, you could agree with Robert. Doesn't mean necessarily that those views are mandated by the Second Amendment. So that's there's room between the policy conclusion and what the Second Amendment necessarily means. Then just a brief hit on each of those, right? So when Robert says, you don't have a right to resistance against the duly enacted laws, well, part of what, the Michigan militia group is saying is that, Governor Whitmer is not the duly constituted authority, that she's a usurper, right? Again, we can say that they're wrong, but that doesn't mean that they're not going to go out there and claim it. With response to Dave, I agree that the framers had in mind, and Federalist 46 is pretty clear about this, right, that it's the states that are going to be the organs of resistance. But that doesn't mean there's going to be a consensus, and we have a pretty powerful example of that in the Civil War, as an example where the whole system fell apart precisely because some of the states thought that they were overthrowing a tyrant, and the others thought that they were rebelling unlawfully.
And then lightning round to Robert, and then Dave.
All right. I mean, I guess in response to this, I'm not quite that relativistic about things. The flavor of this argument just reminds me of arguments for moral relativism, where it's like some people think, doing X is moral and some people think it's immoral, therefore there can be no moral truth. I don't think that's, I think that argument has that kind of flavor to it. I don't think that's right. I mean, first of all, in the ordinary law enforcement context, you can ask very simply, did the person commit murder or did he not? That's not saying that you can't just go around randomly arresting people because I think he committed murder or I think he did something else. So, just because you decentralize political force doesn't mean that you create a completely relative system where we have all the inconveniences of the state of nature. And in fact, in our tort system, one of the requirements for having a lawful arrest is that somebody committed a felony in fact. I mean, that's an objective fact of the matter. So you can't just go around randomly arresting people. On the revolution point, look, political revolution is a dangerous business, and it's not it's not something that I think the framers are pretty clear that you were not to undertake this lightly. And yes, people can abuse it. Blackstone has a comment in his section on treason where he says no private person or group of persons can resist the government that's treason, but this doesn't apply when the nation has risen as one man to enforce the original social contract. And of course, the nation never quite rises as one. There are people on either side of the debate, but I think I don't think it's totally relative either. I mean, I think you can see, do people say leave office after their terms expire, or do they continue office despite the Constitution? I mean, I think there are objective things that you can point to see whether the Constitution and our system of laws are functioning versus not functioning. And the framers would not have recognized a private right of force because you don't like the particular policies that are in place, which are the nature of a lot of protests today. But that is different in kind from officials who would not obey even basic rule of law norms, like ruling the 10th year into their 4th year term of office.
All right, Dave, and then very, very quickly, so we can get to the next panel.
Very quickly. There's no perfect system, and any system is going to have flaws and errors in it. The historical record shows that the American system is a considerably more life-enhancing, life-saving system than the alternative that they tried in continental Europe and ended up with 87 million dead. The resistance to tyranny is protected against impulsive, impetuous use by the general requirement that as long as intermediate magistrates are functioning, you have to go through them, and only in an extreme case, like after Hitler had wiped out all of civil society, would an individual on their own or a group of individuals be able to make a decision to forcefully resist.
Excellent. And cognizant of rule of law values, I apologize for us having gone over for a minute or two, but please join me in thanking the panelists for a fantastic conversation.
Yes, thank you so much, professors, for your time today, and Professor Blocher for moderating. Everyone, we're just going to take a few moments here, about 3 minutes, and then we'll come back at 2:20 Central for our final panel of the day, addressing gun violence and Chicago. So see you in a few.